on. I wanted to ask you to explain to us a little bit about the non-disclosure aspect of this. So Rule 50.09 is basically saying that the parties, nobody should communicate whatever was discussed at the pretrial hearing. And I was wondering if you could go into this a little bit more for us, and like what is the reason why this is, and that kind of thing for the non-disclosure.
So the general rule in litigation, one of the general rules of litigation is that settlement discussions are kept separate until after the case is resolved and you're talking about costs. But for the most part, settlement discussions are separate. And one of the reasons for that is that they want to encourage parties to make offers and agree to abandon some of their issues and some of their positions in order to reach a settlement. And if that's going to be held against you, you're less likely to do it, right? So there's a lot of different tools and mechanisms set up for you to offer, make offers, abandon some of the things you're looking for in exchange for something else without it hurting you. And that's why that rule is here. If you speak in a pretrial conference about asking for half of what you're originally asking for, or saying, I'll admit that I did whatever you're accusing me of doing or whatever.
Right.
They want you to encourage you to do all that stuff to facilitate a discussion, but then not have it thrown against you when you're actually in the trial, right? So part of that is to say, well, if the judge that's hearing that you say all that stuff is actually going to be hearing the trial, well, how can you take it back? How can you make it so that he never or she never heard that? The rule is just no one's allowed to talk about what happened there. It's similar to mediation. It's similar to a without prejudice offer that's sent. And then the same judge that's listening to all this stuff will not be the one to hear your case and won't know about all those admissions you're willing to make and all those settlement offers that you made before.
But what happens if the other party is not playing fair and they disclose these discussions at trial?
So, truthfully, things like slips where someone says something happens very, very frequently. Yeah. Now, judges are used to it. So if you make a comment that was called settlement privileged, yes, the judge will probably pick up on that. Oh, that probably sounds something settlement privilege, and stop you. If the other party is doing that, yeah, you should pick up on that. Hey, wait, I said that, as part of a settlement, and then quickly, stand up and say, hey, I object to this being discussed here. Right. And if the judge agrees, then the judges are smart; they'll put it out of their minds. Okay. And if it's on a document that's being passed around or being included in a document brief or something like that, then you have to object to that document being put in and either make a motion or bring it up to the judge or something along those lines.
Right. So don't fall asleep when you
don't fall asleep. And
no, yeah, right.
It's very important. That's very important.
For sure. So at the pretrial conference, would the pretrial judge ask each party to tell him or her what kinds of offers to settle has been passed around?
That could very well be asked.
Oh,
that could very well be asked at a pretrial conference. Remember, we're talking about settling the case.
Yeah, so
they're going to be offering things
at the relevant, right?
Conference. It would be. I mean, I don't know if it's a judge running a pretrial conference is going to have their own style.
Okay.
And they might ask that, they might not, but it's not. I wouldn't think that that's an inappropriate question at a pretrial conference.
Yeah, that kind of makes sense. So like we were discussing before, I think I was going to ask you about that rule about how the pretrial judge, because you mentioned that the pretrial judge should be separate from the trial judge. And the reason for that is because, if you're disclosing things, you don't want that to kind of like be heard by the judge who's actually hearing the trial. Right. But I see that in the rule, let me just bring it up for a second, Rule 50.10, it is actually possible for a trial judge to sort of like, to have an exception, so to speak, that the trial
Right.
judge could hold a pretrial conference, so to speak. Can you explain that a little bit? Like, does that happen often? So I'm looking at Rule 5010
Sub 2.
of 2. Yeah, it says it does
Yes.
not prevent a judge.
I have it here as well.
Yeah.
Mhm.
The book. Yes.
Yes, the book. Sub Rule 1 does not prevent a judge before
Yeah.
whom a proceeding has been called for hearing from holding a conference either before or during a hearing to consider any matter that may assist the just without disqualifying himself or herself from presiding at the hearing, right? So,
Yeah.
right, that contradicts what we just discussed about
Exactly.
the judgment on that side. Okay, so I'm not going to go into the details about this, about how you would go about allowing a judge to still hear the trial,
Yeah.
or the motion or the application or whatever it is,
Right.
whether you need consent or from all the parties or whatever. I'm not going to talk about any of that. What I'm going to say is there's a lot of very complicated, long, dragged out, expensive litigation in Ontario.
Right.
And I'll give you an example here. Let's say it's a patent case, right? There's some little piece of technology, something that is very complicated, and the two parties have been fighting about it for 5 years, and it's cost everyone millions of dollars. If you've had a judge that's done the case conferencing for that understands it, the engineering behind all this stuff,
True.
that knows, the history of the case. I mean, this isn't a case about really offers to settle and giving up positions and stuff. This is about understanding that real technical minutia. You might not want to bring a new judge on board to do the trial because you spend so much time and so much money educating this one judge who knows you, who knows the parties, knows the issues. If in a situation like that, it might be better to have that judge actually decide the matter. It might not, but it might. So the rules don't eliminate that judge from doing it, right? But the default is to have a different judge in most circumstances. Hear the trial, hear the application.